Our second panelist is Karen Harned, Executive Director of the National Federation of Independent Business Small Business Legal Center. Along with 26 states, the NFIB joined the lawsuit at the Supreme Court against the healthcare legislation. Karen has argued passionately on behalf of small business owners and their rights to own and operate business. As an associate at Olson, Frank & Vida, she specialized in food and drug law and represented several small businesses and their trade associations for Congress and federal agencies. She also worked as an assistant press secretary for Senator Don Nichols from Oklahoma. She received her BA from the University of Oklahoma in 1989 and her JD from the George Washington Law School in 1995.
Well, it's great being with you all here today. I just think it's wonderful to get together and Clare Boothe does this for you. I do not recall this when I was on the Hill, and I'm very sad because I would have enjoyed it, I know. So yes, I run the National Federation of Independent Businesses Small Business Legal Center, and I'm going to talk to you a little bit about our healthcare challenge today. I'm going to be probably a little light in my discussion on our actual legal arguments. I'm going to save that for question and answer to the extent you all want to discuss those. Since we're waiting the decision, I thought I'd get more into what's actually going on at the moment. So anyway, the right to be left alone is indeed the beginning of all freedoms. This quote from Supreme Court Justice William O. Douglas could have just as easily been written by one of the 7.8 million women small business owners in this country today. According to the U.S. Census, in 2007, women-owned firms accounted for 28.7% of all non-farm businesses in the U.S. Women-owned firms employed 7.6 million people and generated $1.2 trillion in sales. Another 4.6 million, or 17% of the non-farm U.S. businesses, were equally owned by men and women, 50-50. These firms employed 8.1 million persons and generated $1.3 trillion in sales. Like all small business owners, women started their business to have freedom. They wanted the freedom to do the kind of work they enjoyed, their way, and on their time schedule. According to a recent NFIB survey, the recession was hard on women-owned businesses. About a half, or 49% of those that are still in business, have lowered their real volume sales, today than they did in 2007 before the recession begins. But as the country works to get back to better times, it's the small business owner who holds the key. After every recession, small business has led our nation to recovery. As you can imagine, over the past several years, people like you, people like your bosses have asked small business owners, what can the government do to help you create more jobs? And their answer has been almost universal. Get out of our way. Yet here we are on the cusp of one of the most historic decisions in the Supreme Court's history that really deals with this very fundamental principle of how big we want our government to be and how much we want our government to control our personal choices, our business choices, how we use our hard-earned dollars. Our founders did fight a war to secure these freedoms, and upon securing that independence, they sought to protect our liberties by enacting the Constitution with the explicit purpose of limiting the powers of government. They believed that limiting federal power, by limiting that, they were preserving our individual rights and ensuring our future prosperity. But in the past century, we have seen that those freedoms that our Constitution gave us have been chipped away bit by bit. And quite frankly, at the end of the day, because of that, because we really do view this healthcare law as, the great crossroads, if you will, for what our federalist system, what powers Congress is going to have over all of us going forward will ultimately be. That is truly why NFIB did join the 26 states in its challenge to the healthcare law 2 years ago. At the time, of course, it was viewed as very frivolous, yet we just saw the court devote over 6 hours, I think it was actually 6.5 hours of time to argument at the end of March, and that was the most that they've heard in oral argument since the landmark cases of Miranda versus Arizona and Brown versus Board of Education. We really think that our challenge is a humble one. If we win, the only law that is impacted is the Affordable Care Act. However, if the government wins, you are going to have a new world, if you will, in America where there will be essentially no limits to what Congress can require all of us to buy or do moving forward. And that really has been something that I've seen, as I talk to reporters in the lead up to the decision, has just been increasingly validated, disturbing to me, if you will, throughout this 2-year process. At every court, whether it was the district court, one of the 3 courts of appeals, or most famously the Supreme Court, I mean, listen to the arguments. The government cannot answer the question where it will end. They cannot answer the question, what can Congress not require us to buy if this health insurance mandate, the individual mandate, is upheld? And that, I think, was what was so fascinating to me watching the arguments firsthand. I say that because, again, we were really, dismissed by so many that just assumed that Congress could do this, that the government could require us to buy these things. And to see so early on in that second day of argument on the individual mandate, the government be challenged on this by all of the justices. Some, truthfully, that are more sympathetic to them, helping to try to bolster them, but the best they really could come up with was, this whole argument that, well, everybody's going to need health care at some point. The health insurance market is unique. It's different from everything else. So for this, basically, we're going to give Congress this one chance. But why we have gotten, and I think you've seen some good writing on this in the last couple of weeks, why we keep on going back to the broccoli example, if you will, that Congress can require everybody to buy broccoli if they can require you to buy insurance, is because of this health insurance market is unique argument, in my opinion. Look, how we eat, whether or not we exercise, whether or not we take vitamins, all sorts of things affect our health. And if you open the door and say, well, in the health insurance market or the healthcare market, everybody's in that, so everybody has to buy health insurance, really, you can easily get to the next, piece. You see this in New York right now with them looking to limit, the size of your fountain drinks, and that sort of thing. It is not a reach to see the narrative develop on the next congressional agenda of what they limit, we do because of the cost our behavior will have on the health insurance market, the healthcare market, Medicare, Medicaid, you name it. And I think at the end of the day, as much as the small business owners that I represent care about the oncoming taxes and all of the bad mandates that are riddled throughout this law, that is what really gets them the most energized. Because for them, like I said before, they want government out of the way. They don't want government meddling into their business. And this is the most intrusive they have seen the government be to date. And it scares them because they don't know what's next. And quite frankly, you all are here, employers are already regulated heavily enough. This is, our top 3 issues have not changed in, I don't know, decades. It's taxes, it's regulations, and it's the cost of health care. And this law really hurts all of those. But on the regulatory component, that really also just gets to the freedom. They've seen those regulations go into effect because Congress knows it can regulate employers. And so with this individual mandate, they think it just pay bars the door. And on that, I would just say, since I'm speaking to women, about women, that what my experience has been in the 10 years I've been at NFIB is that if you're a business owner, you're a business owner. It's not, your business isn't defined by your gender at all. And the problems that every business owner faces, again, are taxes, regulations, and healthcare costs. And it doesn't matter whether or not you're a man or a woman, because those are all issues that impact your bottom line and your ability to make payroll and to stay in the business. And so for that reason too, I think this is a timely topic for you all, because I do think that there really is no difference for the business owners. We represent men and women alike, and they all share these concerns equally. As far as the healthcare decision itself, again, we do expect, obviously, that the decision is going to be next week. There were 4 issues that the court was asked to consider in 3 separate cases, so it may very well be a situation where they release, one opinion, that's red, then the next opinion, that's red, and those would be, the individual mandate, I think, was coupled with the Anti-Injunction Act. They probably deal with both those issues at the same time. The Anti-Injunction Act was the first day. That's an old tax law that prevents all of us as taxpayers from suing the government over tax penalties that we think are unjust until we've actually paid them. And the question, of course, was the penalty attached to the mandate that we buy health insurance a tax or a penalty? And I'm sure you saw in the coverage after, it was very humorous when Alito, challenged the government that day, because they did say, look, the Anti-Injunction Act, the government argued, does not bar this lawsuit at this time. And Alito said, okay, so today you're saying it's not a tax, and tomorrow you're going to be back saying it is, which isn't. And that was a nice, awkward, from my perspective, awkward moment for the government. But that is the threshold question, is whether we could bring our lawsuit at this time. And I'm hopeful that the answer will be yes. It did seem to me like the justices were very skeptical of this whole taxing argument that the government was offering up. On the individual mandate day, I mean, you've seen the coverage as much as me. It was very, I've gone back and listened to the arguments. The government really did get a sound grilling, if you will, from the justices on where the limits were. And I think that, at the end of the day, however that opinion goes, the limiting principle question, what Congress can or can't do going forward, I think is definitely going to be the center of that opinion. Obviously, we hope that they say the individual mandate falls and that Congress can't require you to buy any product. But even if they allow it to go forward, I would like to think that they're going to articulate some limits to Congress's power that are easy for people to understand and go by going forward. And then finally, the last day we had the whole question, and this will also, I think, be really interesting also to see how the court splits on this. What happens to the rest of the law if the individual mandate falls? So if we are fortunate and the individual mandate does fall, will it be a clean 5-4-6-3 decision on what comes next? And by that I mean where you're just going to have a majority opinion and it is said with some concurrences, but as far as on the judgment, yes, it should fall, or no, it shouldn't, or pieces should. You've got 5 votes here, 4 votes here, and you've got them for the reasoning. Or if you're going to have like a plurality of opinions, you're going to have like 3 or, God help us, 4 opinions that cobbled all together, you get to the 5 votes. And then you have to figure out, well, who did they need to get that vote so we know that this is the opinion that we really care about going forward. By that I mean, there was a case a few years ago when it was a property rights case, it was called Rapanos versus U.S., and in that it was a plurality opinion, and what happened was with Kennedy's vote, they were able to get the 5 votes, but he didn't sign on to Scalia's reasoning on how to get there. And so it was really Kennedy's opinion at the end that controlled. So that'll be interesting to see whether it's plurality or just a straight up or down, majority dissent, opinion. And then finally, they have the Medicaid issue that they'll be considering and answering on whether or not Congress can basically give it a take it or leave it to the states. Can you either best do everything we say when it comes to Medicaid, or you lose all your Medicaid funding. But at the end of the day, again, the small business owners I represent very much value their freedoms. This case is very much about freedom for them. And men or women, we are very hopeful that we will ultimately prevail on this lawsuit, and I'm sure all of us will hopefully know the answer this time next week. Thank you so much.